So in this video, I'll be going through a number of questions to address, and then I'll just go through the answers with you as well. So the first one is client A and B want to set up a business solutions business, and their main concern is to raise finance. Client A would prefer not to disclose. Client B has just bought a new home and they want to ensure they have limited liability. So which would be the best structure? So the answer is private limited company would be the best based on their requirements. So they want limited liability and they don't want to disclose. They do not want to disclose. Question number 2. Okay, a private limited company proposes to pay off the bank overdraft of a director of its holding company. On understanding that the director will pay the company back over time, there are no other companies associated with the company. Which statement best explains the nature of this transaction and whether shareholder approval is required? So this type of transaction is called a quasi-loan, and it's to a director of the company, for which shareholder approval is not required. That's question 3. Okay. So private limited company was incorporated in May 2002, has a issued share capital of 30,000. The shares are owned individually by 2 shareholders. They've agreed to issue 1,000 to a new shareholder for 25,000. These preference shares grant a right to the holder to claim a fixed dividend, no right to participate in surplus profits, and no right to return any surplus capital on winding up. In 2014, the company adopted model articles with one amendment to the chairperson's casting vote. What shareholder resolution will be required to issue the preference share? So you should know this from memory. An ordinary resolution is required to grant the directors an authority to allot the shares, and a special resolution to amend the articles to issue the new class of shares. Question 4. The shares in public company incorporated in 2011 are now being sold to another company. The buyer is taking out a bank loan in order to fund the purchase, and they're seeking security with assets. And the buyer's holding company and security over the assets of the target company. How can the companies involved provide the required security? So both the buyer and the buyer's holding company are able to provide the requested security. However, the target company is prohibited from providing security since this constitutes unlawful financial assistance. So since target company is the private company, whereas the other ones are protected by security, therefore they are able to, however the target company cannot. A private limited company has 4 shareholders. The majority of shareholder has 88% of the voting shares, the other has 4%. The board of the directors wishes to call a GM of the shareholders using a short notice procedure. What is the minimum number of shareholders who need to consent to the calling of the general meeting? So it needs to be the majority shareholder and 2 of the minority shareholders. Three friends are into business and they intend to make a partnership. So which of the following tells you which is the correct option? So it would be number D. They have formed as friends in their business with a view of making a profit. So you act for a company, there are 4 shareholders. Person D is one of the directors of the company. The company is a private limited company with unamended model articles and no shareholders agreement. Person A, B, and C are unhappy with D's work. D as a director, all 4 shareholders of the company plan to be present and voting at the companies to the removal of person D. So which shareholders will be able to pass the resolution? Person D may vote against their removal at the GM. However, person A, B, and C will be able to achieve the necessary majority to pass the ordinary resolution to remove D. A company incorporated in 2015 with unamended model articles is planning on entering into service contract. The contract stipulates a term of 1 year with an option for the director to renew the contract for the further 2 years. There is also a clause allowing the company to terminate the contract at any time on giving 3 months' notice. So does the proposed service require prior shareholder approval? So no, it doesn't, because the service contract agreement guaranteed term is 3 months. Your client wants your advice in respect of the changes that need to be made to the recently purchased shelf company. The shelf company is a private company limited by the shares with unamended model articles. The client wishes to change the following as quick as possible: to the name, the board, and the shareholders. So which resolutions will be needed to effect these changes? So special resolution will be needed to change the name of the company. Board resolution, one board resolution to appoint the new directors, followed by one board resolution to accept the resignation of the old directors, should be used to change the directors of the company. A board resolution could be needed to approve the share transfer and the entry of your client's name into the register of members. Question 10. So there are 3 people who want to make a profit, not taking legal advice, they contributed to the capital. So what entitlement do they have? So each partner is entitled to the share equally in the profits, but they're not entitled to a salary. Now this also comes from memory, so make sure you memorize these rules. A board of directors of a private limited company with unlimited wants to sell some machinery. The company has 3 directors. The sale proceed would be around 95k. The sale price has been independently valued. The company's audited accounts say that there are 900,000. Does the sale of machinery require shareholder approval? So yes, it does, because it exceeds the 10% of the company's value, and the director's son is a connected person. So what's a connected person? So someone from your family. It exceeds 10% because it's over 90,000, which is, if you do the maths of 900,000, that would give you 90,000, which is above. So yes, it does. Since it's above 90,000, it will require shareholder approval. So 2 directors, and a few days prior to the incorporation, one of the directors signed a lease for new space to be used by the company as a director for and on the behalf of the company. Is the lease binding? The lease is not binding, but will be binding on the director who signed the lease on the company's behalf. A group of 5 entrepreneurs wish to set up and run a business. So each investor has a limited liability, flexible management is adopted, and setup costs need to be kept at a minimum. So would setting up this business meet the entrepreneur's requirements? So yes, they do. However, there is no requirement for the memorandum or a particular management structure, apart from the need of at least 2 designated members. A minority shareholder with 5% of the shares is very concerned about the company's current financial situation, because it's being worse and worse by the mismanagement of the company's finance. They would like the shareholder to purchase but the other shareholder, they're not willing to do this. So what claim can they bring? So the shareholder could bring a claim for unfair prejudice, section 994, the Companies Act 2006, against the company. The company has 4 shareholders and they all own 25% of the shares. A and B are not happy with one of the directors, C, and they want to remove him. D is not sure. There's a shareholders agreement in place, which all of them have signed, and the shareholders must unanimously vote to remove a director. Will the shareholders be able to remove C as a director? So A, B and D could pass an ordinary resolution to remove C, but C would likely have a claim under the shareholders' agreement against those shareholders that wanted to remove them.